Good afternoon, everybody. My name is Peter Neufeld. I'm a partner at the firm Wagner Sidlowski and the co-chair of this Lunch and Learn series on strategies, advice, and the elderly, along with my colleague, Professor David Friedman, who will also be one of the primary speakers today. The subtopic for today is about the first meeting and ongoing representation issues of testamentary capacity. So dealing with issues of testamentary capacity when you're meeting your client for the first time who may want to prepare a will, or maybe it's an ongoing retainer and they have instructed you that they want a will prepared. A paper on this topic was prepared by one of our firm's associates, Esther Mendelson, in advance of today's seminar on this topic, and a link to that paper can be found in the Zoom chat. The certificate of attendance for today will also be posted in the Zoom chat momentarily for you to download. Remember, when the Zoom meeting ends, you can't access those documents anymore. So before we end today's hour long presentation, just make sure that you download anything that you need beforehand. Great news, the seminar has also been approved by LawPro for a risk management credit program. It's eligible for a $50 credit claim. So we ask that you refer to the document posted in the chat for details on that. Again, a big thank you to our sponsors, Scotia Wealth Management, the B'nai B'rith Concentric Trust, Weir Folds, Donovan Kochman, and Torkin Mains. This event is complimentary because of them. A few housekeeping notes as usual. Please make sure that you have your microphones muted at all times unless you're asking a question at the end of the presentation, after which we ask that you mute yourself again. Please also note that this seminar is being recorded. We have two presenters today. We have Professor David Friedman, as I mentioned, and Raquel Levine. David Friedman is a professor at the Faculty of Law at Queen's University and counsel at Wagner Sidlowski. He teaches and writes in the areas of wills, estates, trusts, and guardianship law. And he'll be accompanied by Raquel Levine. She is counsel at Wagner Sidlowski, and her practice includes, among other things, the drafting of wills, trusts, and powers of attorney. Her clients include estate trustees and executors requiring advice on the administration of an estate, as well as applications for certificates of appointment and other related matters. If you've enjoyed our seminar or this series, we ask that you consider making a donation to the B'nai B'rith Canada Food Program if you haven't already, or if you'd like to make another donation, we ask that you do so. The link for that is also in the chat. Cheryl Landy, the Director of Community Engagement at the B'nai B'rith Canada, is here with us today to tell us a bit about the organization and its charitable work. So Cheryl, if you are there, you have the floor.
Thanks, Peter. Can you hear me?
I can.
Okay. Hello, my name is Cheryl Landy, and I'm the Director of Community Engagement at B'nai B'rith Canada. For many decades, B'nai B'rith Canada has proudly sponsored Wagner Sidlowski's CLE programs. We value the long-standing relationship with your firm and the important work you do in the legal community. While B'nai B'rith Canada is recognized as Canada's oldest human rights organization, dedicated to combating hate and advocating for the Jewish community, we're also a passionate advocate for some of Canada's most vulnerable community members, including Holocaust survivors, isolated seniors, and those living in poverty. Throughout the year, I'll be highlighting some of our key initiatives that support these individuals. These include programs focused on housing, clothing, food insecurity, and social connection. Today, I want to briefly tell you about one of our most vital initiatives, our weekly food bank for seniors. What began during COVID has now grown into a lifeline for many of our community. Each week, we deliver food boxes filled with fresh vegetables, fruit, and sources of protein. But these boxes carry more than food. Many of the seniors we serve are isolated with little or no family nearby. For some, Our volunteers are the only friendly face they see all week. That weekly knock on the door isn't just a delivery. It's a moment of connection, of conversation, of being seen and cared for. Since the program began, we've delivered more than 30,000 of these boxes and just as many moments of kindness and dignity. Each week, our team of dedicated volunteers carefully packs the boxes while another team delivers them, bringing not only nourishment, but also a warm smile and human connection to recipients from across the city. Thank you again for hosting this Lunch and Learn and for your continued support of B'nai B'rith Canada. I look forward to sharing more stories with you in the months ahead. If you'd like to help us continue with this vital work, I invite you to make a donation to B'nai B'rith Canada, bnaibrith.ca/donate. As Peter said, the link is in the chat. Your support enables us to reach more seniors, deliver more food, boxes, and provide meaningful care to those who need it most. Thank you again for standing with B'nai B'rith Canada.
Thanks, Cheryl. We really appreciate it. We're going to start with the presentation now. David and Raquel, you can take it away.
Okay, thank you, Peter. So as Peter mentioned, we're going to be talking about testamentary capacity today. So let's first talk about what is testamentary capacity. So it's, we're talking about the ability to make a testament, which is a dispositive document. Normally, we're talking about a will in the context of our practice. And there are 4 aspects of testamentary capacity. The first is understanding the nature of the act and its effects. So at its very base, what is a will? A will does something. It gives away your assets after you die. So does the person have that level of understanding as to what they are instructing you to prepare and what they will ultimately be signing? Understanding the extent of the property being disposed of. So do they have some understanding of what it is that they own? For person to comprehend what the claims might be. So if we were to think of who a person's, let's say, natural heirs would be, spouses, children, are they thinking about these people when they are giving you instruction? And as well, is there any, we'll call it disorder of the mind. So if there's any cognitive impairment that is interfering with their ability to understand the first 3 items, or they understand the first 3, but that leads them off perhaps into some other kind of direction. So let's just think about what is testamentary capacity and what it is not, right? So again, we're looking at the ability to instruct counsel with respect to preparing a testament. It's a specific band of what falls under a person's general entire mind. So it's related to judgment, it's related to mental health and ability, but it's not strictly judgment, where you could say to yourself, do I approve of this person's judgment? Do they have generally good judgment in their life? A person who is suicidal could have testamentary capacity. They might be have cognitive impairment in some other area, but it might not affect their ability to understand what a will is, how much they own, and who they want to leave it to. You could have an impulsive person. You could have, I'm sure everyone in their own family has the crazy aunt, uncle, or whomever that no one really wants to talk to at any party. They may have testamentary capacity, but you might not necessarily trust them with your own money, okay? Or they could be very bad with money, right? So there's an aspect of judgment, there's an aspect of mental health, but they're not 100% measure for measure traveling together. Because of that, capacity is really viewed sort of as almost on a spectrum, right? So you would have sort of on one end, a man in a coma, okay, would have like a very clear lack of capacity. They're not communicative, they're not responsive, you have no idea if they know anything, right? And on the other side, I think you'd have what clients that many of us are meeting, clients who you don't even really give a second thought to the capacity. They're working adults, they come in, they're articulate. Those are the ends where we're not so worried. I think where we want to talk more about is people in the middle, or people sort of on the coma end, people who are in the for those who have seen the movie Weekend at Bernie's, that's not the type of client you want walking in your door. But you do meet people who could be, perfectly upright walking in, and they come in and they're the kids tell you, we'll be outside, he's totally fine. And when you sit down with him, he's not making any sense. So capacity is really a very flexible assessment, right? Because it's extremely fact dependent, right? And so you're not necessarily going to find that you have two people or two cases where the exact same fact pattern played out in terms of the person's perhaps their speech, their physical ability. There's so many factors that can go into a conclusion of capacity or a conclusion of lack of capacity. And for that reason, when you're veering more anywhere close to a scenario where you feel that you might want to be more on guard for these issues, okay, it's going to be very important that at the times of the meeting or shortly after the times of the meeting, you have written down and made note of or recorded your observations, right? Because the person may come to see you today, but they could pass away and people only find out about their will in 5 years, and everyone's going to be going back 5 years trying to remember what that was like. And so we want to make sure that everything that we are doing as solicitors is recording the facts as we see them at that time. I'll give you some examples in terms of different factors that might lead us to become on guard. So I think age is a factor, okay? But again, not the factor. I don't think there's one determinative factor. When someone comes in and they are older, you might just feel a little more on guard and that you need to be monitoring for these things. I met a 100-year-old 2 weeks ago. He came to my office, and I wouldn't try to get anything past him. And so it's not that he's 100, therefore he is incapable. He's 100. I might just want to keep more notes than normal as to everything that went on in that meeting. Now, again, we are taking the notes today, we're taking the instructions today, but the will is going to be read in the future. So if there's some sort of question about capacity, what will the courts be looking at to determine, using their time machine, did this guy have capacity, right? So the investigation is going to center on, three main bodies of evidence. The first is solicitor's notes. The second is lay evidence from those who do the testator, right? And the third is medical evidence. Now, as lawyers, we have really the best control over our own notes, and our own notes will be our savior. So I want to focus now on talking about some best practices that we could employ and some ideas as to how we could have our best possible solicitor's notes if that capacity is ever put into question. So there are two types of notes that we typically have, or recordings in our file. One are notes, internal notes. So our notes of the meeting, our impressions of the meeting. And then there is obviously written material that goes out. So those are both opportunities, both our internal and external note-taking and correspondence, to have contemporaneous knowledge and recording of what has occurred in your interactions with the testator. So an engagement letter may be a place where you would like to discuss items from your pre-meeting, for those people who have a practice to speak with the testator, perhaps on the phone or by Zoom for 15 minutes before agreeing to a sit down. That might be a place to discuss, thank you for engaging me. Your daughter will be bringing you to and from the appointments, but we will not be letting her in. or other details that are facts of what occurred, but unless you write somewhere, your daughter brought you to the appointments, but she was not in the room, we're not going to know in 8 years' time what happened, or we're not going to at least feel very, very certain. It's very hard to remember, and I think this is harder to see earlier in practice. You wonder, how could I ever forget a file? Well, like, just fast forward, and you will know, you will forget your files, or you will forget, that sort of granular detail that you maybe had when you only had 4 files. Very easy to remember everything. But years and years later, all you have is your good notes, and your notes will help refresh your memory, but no notes are going to be very difficult to refresh your memory. When you open a file and all you see is a will and a bill, the client is always going to have, or the client's family is going to have more recollection of the person than you, who will have met the testator, I don't know, 2, 3 times, right? And they will say, I live with them, or I met them for dinner every Sunday. I know what he was like. Note-taking of the meeting, very important. I don't know if any of you use some kind of uniform notes or rubric to try and make sure you've captured everything. But in terms of facts, it's important, such as information about bank accounts or address, but also to build in some space for discussion, right? Conversation, right? So if the person, the testator came in and you guys discussed a certain plant that's in your office, right? That would be a nice thing to note down, right? If you feel that you are in that area where you want to be a little bit on guard, right? The testator noticed the plant, he discussed how much he loves gardening, right? All of these details really are going to help try to fill in a photo. This is almost like every data point that we can gather, right, about the testator and what his mind was like. If you think of each of them as a pixel, right? And we're trying to really have as much high resolution in the picture of the image of the testator that we might want to summon in 5, 8, 10, 20 years time, right? So while the family's saying, well, the person was pretty well catatonic, and your notes indicate that once they're alone in the room with you, they wouldn't stop talking about the Blue Jays or something, then that's important information, because a testator may also speak with you differently than they speak with their own family. Their own family may have less patience for them, less interest in hearing about what they have to say. Even though a lawyer's visit is somewhat transactional, some families really could view someone in their life with, I'll say, diminished capacity in a very transactional way. I'm taking you to your appointment, I'm driving you here. And, there's a lot of obviously personal, emotional stuff that we try to stay out of best as possible. So those are some extraneous details you could include to sort of paint a picture of how the testator behaved. You could also have discussions that were leading to a specific choice. So for example, sometimes you have testators with children in different jurisdictions. So they have 4 children, 2 live here, one's in Australia, one's in Brazil, and he likes them all, but it's not practical to name we'll call them the international children. And he would prefer to name one local child over the other, because one of them is an accountant and the other one's, I don't know, an artist, and he just feels more comfortable. So yes, the answer that you're going to need in order to draft the will is, child 1 is the executor. But the discussion, well, we talked about, naming all 4 children. We discussed it's difficult. You decided that you'd rather have, right? Having all of these details, as opposed to just the answer, child 1, right? You could have put child 1. You could have talked them into child 1. Now we see in your notes that there was a discussion, and there was, thought, and, the great expression. The testator turned their mind to the fact that they have 4 children. They're living in different places. We sort of weighed out the pros and cons, and this is the conclusion we came to. So I think it's always challenging to speak and take notes. Perhaps you have a note taker in your office who comes, or you can do your best to keep your notes, and then you can expand on them later. You can sort of have an expansion of your notes based on your own point form. And although that's can be sort of a drag because there's always something new to do in the next emergency, but a half an hour invested now will be a lot easier than 4 hours trying to reconstruct this file if anyone calls. So you look at it as an investment in your future. When you have less memory, you have just your own less working memory of that one meeting, right? As to when we discussed who would be the executor. And then some of these discussions and these deliberations can go into a letter back to the client, right? We discussed, who will be the executor. You decided that although you love all your children just the same, you're picking Andrew because Andrew is local and is an accountant and, et cetera, et cetera. So not only are you naming it in your own notes for yourself, if capacity is called on and your notes must be produced, but you're also sort of parroting it back to them. Firstly, it's nice to confirm those things in writing. I like to always give my clients what I call like a regular English summary of what's in their drafts, because listen, I don't know if you have the same experience, you give the client the draft will and like, that's it, they fall over. Like nobody likes to read. They're not going to print it. They're not going to scroll on their phone. It's too much scrolling. Their index finger hurts. I like to at least satisfy myself that in like shorter sentences, they know what they did, right? And then, also it helps because perhaps they didn't understand what you meant, and that could be a capacity thing or not a capacity thing, but they'll say, oh, I thought about it. Now that I see it in black and white, like, I don't want Andrew. Maybe we'll name all four of them and they'll figure it out, right? The famous client thing. We'll all be dead. I don't care. So a letter with the drafts could be very, very helpful, right? And then at the time of the reporting letter, depending on how much detail you have in the reporting letter, you might want to include other details that have to do with, the review meeting, when you signed, where you signed, who was with you when you signed, if you feel that that's an important detail. Overall, throughout the duration of the retainer, effective communication with a client where you have some kind of like capacity doubt, where they're not a capacity slam dunk, very important. I have found that there are some clients, sometimes they are like horrible on the phone, better on Zoom or in person where they can see my face, they can see like my gesticulation. They need some kind of facial, expression in order to understand what you're saying, right? So I've had clients who've been, for sure, like disaster on the phone makes much more sense in person. And sometimes I'll note that, right? I'll make a note. The client is much more decisive today in person than they were on the phone. And especially if their family speaks to them mainly on the phone, they will view that testator as like kind of messed up upstairs, but and they may not see the in-person version of them is much clearer and can understand better with some kind of facial cues. Also, sometimes we need to tone it down with our vocabulary, not in a document like a will that I tell my clients, like, I only have so many choices on how I word things and it's always longer, but in our own communication with a testator, we can choose verbally and in writing to make our letters shorter, to use regular words, to have use more analogies. I guess you have to see how the client understands. You want to have a satisfaction that the client understands what they did. And rather than saying the purpose of this disposition is, like you do this for so long, you forget people don't talk like that. Nobody talks like that in the regular world, right? So we can use the letters and our phone communication or however you're speaking with your testator to give them understandable sound bites, right? Because when we're going back now, if we go back to those elements of capacity, right? Understanding, the claims or understanding the nature of a will or the effects of the will, it doesn't mean that they are at an expert level. It doesn't mean that they are at the level of a lawyer who's been practicing, right? That's not the point. If they were at that level, they would do their own will. They would write their own power of attorney, right? Typically, the clients want to hear the executive summary. What am I doing, right? You are making a will, giving this person is your executor. The executor is like a manager, right? Bringing it into their realm of understanding, right? So they don't have to understand all the long paragraphs and do they need to write an essay on the rules against perpetuities? And, there are a lot of things that are technical in detail, and that's our job. And similar to when you go to the dentist and the guy, I don't know, but your dentist starts explaining, I'm going to extract, I don't want to know. You take my tooth out? Yes, good. Okay. You want to just have the upshot, right? What is it that we're doing? Tell me in simple language, right? In layperson language. And if they understand you in layperson language, right, that's a different problem than they don't understand you in layperson language, right? That's the difference between capacity and I'm educated in law, right? So wherever possible, we want to make sure that our clients can understand what we're doing. And when things are made simpler for them, the capacity problem just gets a little clearer, because if I'm explaining to somebody something in very complicated language and they are not understanding and they are just frustrated, and that might not be a capacity problem. That could be the way I'm explaining it, right? But if I explained it in simple terms, or they might, David and I will get shortly to talking about different types of clients who might have a harder time with this. It's incumbent on us to make sure that they know what they're doing. And if we feel that after, really, really bringing it down, they're still not getting it, then you might be getting to a problem that cannot be overcome with, even like, baby's first will kit is not going to solve your problem. David, I'm going to bring you in just to talk now a little bit more about effective communication and documenting instructions.
Okay, great. If you don't mind, I'm just going to back up a little bit, and
Sure.
I'd like to reinforce some of the things that Raquel has been talking to you about. And I should say it's an honor to be Raquel's unlovely assistant for today's webinar. I'd just like to say from a litigation perspective, and use a phrase that nobody here wants to hear: professional negligence, where the same issues come up. I looked at the list of the people that are attending today, and I see a lot of familiar names. I know that there are a lot of people that are attending that have been practicing for many years and have a lot of experience, as well as some much younger practitioners that are just getting started. And I think what I'm about to say is going to fall a little harder on the ears of those people that have lots of experience rather than the newer lawyers. The law and practice has changed a little bit with respect to professional negligence. Liability for will drafting and negligence is only about 25, 30 years old. And we're seeing more of it. And it's necessary to think about yourself and, putting on your own mask, protecting yourself against a possible action against you at the same time as protecting your client's will against a later challenge. And so I'd like to just make 2 points that I'd like you to consider. The first is, I know that we're providing services to our clients, but in drafting a will, you're also a fact witness. And I think it's very important to think of yourself as a fact witness. You can create evidence that is useful later, as Raquel has set out. Professional negligence standards mean that we have to take and preserve notes. And those are notes primarily about instructions. However, as a fact witness, you really are in a unique position where you can create and preserve evidence that's going to be useful later. I once had clients that were software developers. They had a small company, and the fellows that had this company were both former military intelligence officers. And when I would ask them to, write me what the story was on some point, I was amazed at what came back. I mean, the level of detail and how they took account of the surroundings for different transactions was really interesting and not something that I had seen before. I mean, for them, they were used to preserving all kinds of details that might later turn out to be important. And I thought that was really it was really interesting to read. And there's a lesson in that for me, which is that if you're dealing with, especially older adults and you're seeing with them on more than one occasion, you can not only set out notes as to what you said to them and what they said to you, but you can preserve evidence of their demeanor, whether they were appropriately dressed, did they sit properly in their chairs, did they appear to be in pain? All of those kinds of things can be noted if you're minded to do so. So I think that when you consider yourself not only a service provider, but a fact witness that to a potential challenge to the will later, if you create the evidence that would assist the court in understanding the context in which your assignment was carried out, the instructions were provided to you and what you did, that's really powerful evidence. And so that's one thing to think about. The other thing is systems. And this is unfortunately where I think a lot of people are reluctant to change the way they do things. But the law is changing and standards of conduct are changing. Doing things on an ad hoc basis is easy. And when you're an experienced practitioner, you know what to do and you're going to get around to all of the important parts. I would suggest that having a system in place is the most important thing of all. It's something that you can follow. It's something your clerks can follow. It's something, if you have associates, they can follow. And having a system means that not only you're not going to make mistakes, you're going to be able to create evidence that's appropriate. So, for example, and you don't have to do this, but this is just as an example. One good thing to do before the execution of the will is to print out an extra copy of the will that you have in front of you, as well as having the execution copy of the will in front of the client, and go through the will with the client. If they appear to understand or they have no questions, initial that paragraph. If they have a question, note it down and what your answer was in brief. At the end of that, date it, sign it, throw it in the file. That can then be used to refresh your memory if you're called upon to draft an affidavit or to make an affidavit or to testify in court. And having that in place as a system, you get to say, no, every time I do this, I explain the document to the client, I note that they've appeared to understand, and I've noted any questions that they've had and how I've answered them. And that is really, really, really powerful evidence that can be used to prove capacity after the fact, and is extremely helpful when we put that evidence to a geriatric psychiatrist or neurologist or whoever the expert is that's going to give an opinion about capacity, is they get this really fulsome picture of what went on when you were taking instructions and were explaining the will to the client before they actually went and signed it. So that goes to knowledge and approval, I know, but it also goes to capacity. So those are 2 points. Documenting instructions. Boy, this is important. If you don't have evidence as to what your instructions are, if I'm challenging a will or one of my colleagues is challenging a will, that's wonderful for us. I mean, you've given us a nice opportunity to be able to drive a truck through your will. Having a written retainer agreement that sets out the scope of your services is important. Having a system to note what those instructions were is absolutely vital. And I don't think it's appropriate anymore to have, notes on the back of an envelope where you've kind of scratched something down. I think it's really important now to actually take some extra time and to note in some degree of detail what those instructions are, so that if the will, in fact, can be rectified if there's a mistake, we can do that, or we can defend it against an allegation that there's a lack of capacity. The other point I think Raquel asked me to talk about was communications and effective communications. Raquel's talked about how to talk about different clients, you know, in different ways. You know, we're all educated, and it takes a while for us to get back to being able to speak English. But you know, once you've gotten back in the habit of being a normal person, then you can communicate very effectively with your clients. After the fact, if the client is passed and we're now dealing with their will in court, the entirety of the file is going to be produced. And to protect the will, it's necessary to document how the instructions were given, how the instructions were carried out, both in terms of your own personal liability for negligence, potentially, as well as to defend the will. So, and this is, you know, certainly going to be important in cases where capacity is an issue, or you suspect capacity may be an issue after the fact. Preserving your communications, making sure that you have confirmed your instructions in writing or digitally, is really, really significant for ensuring that the will is not going to be challenged successfully. So we can talk about difficult scenarios and how to communicate with people effectively in those difficult scenarios. And you're going to have to use your best judgment when you're dealing with, you know, the clients that are where English is not their first language, and you may have to use a translator that's a family member or somebody else. I mean, those are all really difficult. From my perspective, the problem that I usually see is that just no evidence as to how the information was provided to the client, how the instructions were received back from the client, how the instructions were then carried on. So, you know, as Raquel said, sometimes you get a file and it's a will and a bill, and that's not helping anybody other than the people that are wanting to challenge the will. So, you know, again, I just want to reinforce this. If you don't have a system from intake to execution, then I would strongly suggest that you develop a system and that you follow it, because it's much less likely that you're going to make a mistake. And at the same time, it's highly likely that you're going to preserve the evidence that's required to be able to defend the will later. Back to you, boss.
All right, thank you. For those who don't have a system, if I could make some small recommendations. So as we know, you know, every wills file is different and every wills file is the same. There are a lot of fields, if you look at it from like a fill in the blank point of view, that translate from one to the other. And sometimes you can use something as simple as checkboxes or a table if you're in Word to do that. So like David was mentioning, was the client appropriately dressed? I mean, yes, no, right? That's like a checkbox. Yes, no. Did they appear in pain? Yes, no. Where did the meeting take place? You can have 3 checkboxes: on Zoom, in person. You know, you can have different, you don't have to necessarily write out the full sentence every time. Again, we're trying to show that these things were thought of, right? And then it could be a meetings, sort of a meetings template. Like I personally have a meeting template. I have a review meeting template, right? And then I have like some notes on execution. And they're just, you know, they sit in the precedent folder, and every time there's a file, we just, you know, copy and paste those Word docs and apply them to the file. So I always have those. I have, you know, and then I have my draft letter, and they don't necessarily, you know, they're not going to change drastically. Hi, thank you for retaining me. I mean, a lot of these sentences stay the same, but, you know, the details for the file can vary, and obviously what you put in there in terms of discussions and whatnot will vary, but it gives you some kind of structure. I'm not sure how people are working with clerks and whatnot, but certainly like just reams and reams of like, notepad paper with all sorts of thoughts, probably require a lot more thinking in terms of you got to read the whole thing, start to finish. Nothing's necessarily organized in one section. So those are ideas you can think about. And, it is definitely an investment, meaning you will lose some time now, but you will absolutely gain some time later. And also help out with the flow of your staff. Your staff will know that if there's an executor section, no matter what order you talked about it during the meeting, the executor is going to be in the executor section of your notes. So I want to have a conversation with David now about 3 challenging scenarios that I find come up quite a bit in practice, and get David's thoughts from a litigation point of view. The first is, I'll say women in traditional marriages, okay, who may find themselves divorced or widowed and have just about no financial literacy, very little financial literacy, and how to speak to those people and how to take instructions from those people when if it weren't for the fact that their age was good and all their other conversation was good, you'd say it was like fairly impaired. But I've met people who are just pumping gas for the first time. They're just writing checks for the first time. They're 63 years old, right? That's just the way that their relationship was. I met a couple on Friday. I'm sitting at the table with her husband, and she goes, "I don't know anything about the banking. I really don't. I really don't. Tony's been so good to me, And it's very nice that they have this lovely marriage, but she doesn't know a lot, right? So, on my side, and then I'll let David chime in. I think I want to see that the interaction between them seems normal, and it's not that she doesn't know because he's beating her when I leave and he's keeping her down. It's just, she makes like really great chicken and he's really good at the banking, and that's like sort of a normal scenario. But I might take a moment to explain things to her, or speak to her about, well, how would you, if you had this bank account, where would you want it to go? Or how, explaining especially the difference between someone being joint, or even just the concept of having a beneficiary on an RSP, right? I find I have to just get more in detail and put like half of a CFP hat on to explain to them, what does it mean when something's joint? What does it mean when there's a beneficiary? What does it mean to just put your kids on the bank account, right? Because if Tony goes first and this lady's here, I want her to know, or I want her to have heard from me, if she ever remembers, what it means to just put your kids on the bank account, right? It's not just, oh, now their name's there, and right. David, do you have any thoughts on that scenario?
Sure. On behalf of all 63-year-olds, I assume that you were calling us young and inexperienced.
Yeah.
So this question of the unsophisticated client and is an interesting one when it comes to capacity, because sometimes the lack of financial literacy can be used as a pretext upon which to argue that there's a lack of capacity. We started off, or Kel started off by talking about how capacity is, it's directed to what's at issue. And we know from the law of substitute decision making that we regard capacities as contextual, and that's really important for this area of law as well. Like the context is making a will, providing instructions for how property is going to be provided to beneficiaries after death. Where the client is rather unsophisticated, and obviously you're going to need to explain to them how it is that the property will pass to whoever the beneficiary is, and if it's going to be passed jointly or whatever the case may be, it is going to be necessary to be able to explain that the terms to the person and the effect to the person, because there's a huge, as there's a huge difference between leaving a gift jointly and leaving a gift in common ownership or just, individually. So, I mean, it's important to get it right. But again, it's important to note that where the client is very unsophisticated, financially illiterate, perhaps, as in Raquel's example, or perhaps have mental health challenges. That doesn't rob them of the ability to make a will by any stretch of the imagination, but it does make it incumbent upon us to be able to recognize that there is a basis upon which the will may be challenged after the fact, because people will be saying around the same time as mom made the will, she was expressing all of these problems and being able to do all of the things that her late partner had done for her, and maybe that impacts her capacity to make a will. And again, this brings us back to note taking and explanation and effective of communication, so that you do have to wonder, where somebody appears really not to understand what's going on, is this in fact something you suspect that they lack capacity, and you're going to have to now inquire more fully to satisfy yourself that they have capacity? Or it's just a matter of you're dealing with a client that's rather unsophisticated, and this is actually a very nice opportunity to perhaps introduce the idea of becoming financially literate. I mean, I have a file right now where a lady was in exactly these circumstances. Her husband passed. He had done all of the investment, banking, paying bills, etc. And to give her great credit, I mean, she really stepped up afterwards and, taught herself how to manage her money. And that's great. And this is a great opportunity to encourage the client to do that. But it's from my perspective, there is a link to capacity that we should be aware of, which requires you to explore why it is that she doesn't seem to understand how to write a check.
Mm-hmm. Yeah, no, absolutely. And this sort of moves us into our second challenging scenario, which is where we do suspect there might be some kind of mental health challenge, or which could be something that is age-related or not age-related at all, or even a physical problem, right? Where the person just doesn't appear, like a normal ebullient individual, right? So I met with someone recently who's she's in a retirement home. She has mobility issues. She's confined to a wheelchair, and her head sort of tilts. So she's always a little bit drooling. Okay. So if you were to just sit and look at her for 4 minutes and just interact with her quickly, you'd say she's more or less like catatonic, barely there. Okay. But that's the 4-minute view, right? Or a photographic view of her. I sat with her in the sort of like AV room for an hour, right? And I noticed that, I would ask her a question, she would think about it. And while she's thinking, she's looking like this, right? So it doesn't look like a person who's, normally functional, but then, after she thinks about your question, she'll give you an answer, right? She'll ask you a question back that is contextually relevant, right? She'll tell you about her watercolor painting. When I tell her I'm not good at painting, she'll say, start with this brand of paint because it's easy. Like, these are all things that I had some handwritten notes, and then I spent 30 minutes typing up my handwritten notes into full sentences, because I know how this lady looks if you just meet her for a very short time. And if you're the staff at the nursing home who's, dropping her tray of food and picking up her tray of food and changing her diaper, I mean, you're not viewing her in that way. She might not even speak to you very much, right? But, when this woman asked me without any prompt, the assets I have joined with my daughter, is that part of my estate? I mean, that's a very important question that she asked, that showed she knew what we were talking about, she understood it, and she understood it enough to ask the question back, right? So I had sort of my notes in terms of facts. I had notes in terms of questions she asked, things she was concerned with, other things we talked about, like the painting, right? And then I wrote out my impressions, right? Which was that, the first blush is that this woman is not there because she needs a moment to think. She doesn't look great, okay? But like from the neck up, on the inside, she had capacity. She understood what she owned. She understood enough of what she owned. She knew who she was giving it to. She was emphatically clear where it should go. And so, yeah, I spent a half an hour. I probably could have done 10 other things, but I don't know. This woman could live another 10 years, and then where will I be? So I don't know what her diagnosis is, but I'm looking at what facts do I see that let me assess whether she could make a will or not. I think that's more important than finding out she has this dementia, this, it's almost like spoils you a little bit to know what the diagnosis is, because I want to hit my points, right? And I want to know that I'm on guard to say in what areas did they have capacity or show capacity, and become a fact witness, David, like you said.
So I would say that, just to add to it a couple of points.
Yeah.
One is there are lots of situations where you know that there may very well be an inquiry after death, and somebody comes and they have a mental health problem, or brain injury, dementia, something like that, fluctuating dementia, early onset dementia, whatever the case might be. So you know that there's going to be questions, and as Raquel said, you have a duty of inquiry, and you're inquiring to be able to make sure that they in fact have capacity. Videotape. I strongly encourage you to videotape the giving of instructions and preserve that evidence, because that is fantastic evidence. And then obviously the thing that you almost know by instinct, this might be the appropriate opportunity to get a capacity assessment. And certainly it's something that the client may not want to do. It's not the most pleasant experience to have to expose yourself to a capacity, assessment. And if the capacity assessment comes back wrong, there are implications in terms of, immediate decision making. But I mean, ultimately, that's going to be a great defense against a will challenge later. But clients don't necessarily want to do that. And so from the perspective of the drafting solicitor and meeting your own duty of care, I think that at least offering to arrange a capacity assessment and preserving that evidence and the client's instructions in that respect is important to protecting yourself. But then at the same time, recognizing that, in a case where there's a substantial estate and, there may very well be questions that arise later, Raquel has, satisfied herself that the client, though they present atypically, has capacity and may be, very, very intelligent. They just have a communications problem or something like that. But it's enough to cause an inquiry. And so this is when you really need to put, your skates on and try to create, all of the evidence that you're going to need to be able to protect that will later. Or if it turns out that you can't satisfy yourself that the person has capacity you're going to have to refuse that retainer and explain to the client why you're refusing the retainer. Which is I would like to draft your will, but I really strongly suspect that you're not capable, and for the following reasons, and I just don't feel that I can meet my own professional obligations, and if I can't meet my obligations, I'm not going to perform any kind of professional service, because that's just the way life is.
Mm-hmm. Yeah, no, absolutely.
I think we're almost out of time.
Yeah, I know. I have 4 more hours of material, but I'll try to do just the last scenario I wanted to talk about briefly, which was, sort of poor family dynamics and estrangement in somebody who you could see there might be some sort of challenge as to capacity, or at least capacity will be raised when one child is left out, or a spouse is given less or something. And even though they might not have, you might not think that they have a capacity issue, you might want to overdo it a little bit in terms of the notes, more than you might normally, because again, like we said at the beginning, capacity and judgment are 2 different things, right? Someone could say, they never call me on my birthday. Like, how am I gonna leave them? Okay, so that's their choice to be making that decision or writing their own child out of a will because they didn't call on their birthday. But we need to then sort of buttress that decision with notes on their rationale, that we really talked about it, and that their capacity was not in question, so that if they come back and say, well, yeah, they didn't know what they were doing when they wrote me out, right? Because that's going to be the argument. have some sort of rationale that points to judgment rather than capacity on that decision.
Yeah, I would say, I mean, this is kind of like the mentally disordered client.
Yeah.
You know, the client that's changing their instructions and is voicing their displeasure with their children or their concerns. I mean, there's a few things that arise. I mean, one, you're going to have to be concerned about undue influence. We're not talking about undue influence today, but you know, at some point we will, and you'll have to consider that. But then the question becomes, you know, is this delusional or is this rooted in reality?
Mhm.
If it is delusional, you know, does it touch upon capacity, or whether in fact, you know, there just is something else that's going on. And again, you're going to have to inquire a little bit to determine it. This is atypical behavior, which is going to cause there's a need for an explanation.
Mhm.
And so, you know, not dealing with what is obviously an issue is not going to make it go away. And I think you have to be very, very alive, especially with older adults in these situations where you have estrangement and for family dynamics and, you know, changing instructions and all that kind of thing, that on the face of it, there's going to be an inquiry into capacity, and it's going to be necessary for you to really inquire into this and to document why you think that the client is capable, and at the same time is not being coerced by someone else into giving the gift.
Yeah.
Peter's
Agreed.
looking unhappy because I think we're out of time, so I'm going to stop
Okay.
talking now.
All right. I will do the same.
No, quite the contrary. I'm really happy with the presentation, both of you. I really appreciate it. And you know, it's been framed as this presentation's been a great way to for lawyers to understand how to cover themselves when you know coming to the conclusion that someone has capacity to sign a will and they just need everyone else to know it. But it also, I find, gives a real access to justice, or at least access to legal services component here, in that you're giving the confidence to the bar to say that, you know, just because at first glance they might look incapable, that doesn't mean they should be deprived of their right to choose their counsel, of their right to these certain accesses to legal services. You need to probe a little bit further. So thank you both for that. We are out of time. This will be a no question presentation today. That being the case, I do see that there were a couple questions, and I put up and I've made a note of who asked those questions. So I'll be reaching out to them because we don't want to leave you hanging there. So thank you again for everyone that attended. Please remember the certificate of attendance is found in the chat. And we're looking forward to seeing you all at our next seminar that will be called, again, it's about the first meeting and ongoing representation. But as David alluded to, we'll be dealing with undue influence. So, you know, determining whether there is a risk of undue influence when you're meeting with your client for the first time, or maybe throughout the scope of your retainer. That presentation will be on June 10th. We'll have Elena Hofstein, as well as Brad Phillips and Jason Moore that will be presenting. And if you haven't registered yet for that, you can do so in the link posted in the chat. As a final reminder, the link to the B'nai B'rith Canada can also be found in the chat in case you would like to donate. Thank you again to both of you, and we look forward to seeing all the attendees back in a couple weeks.